I don't care what you were told. I'm taking a break. You get your questions in order and you understand how to address this court. Am I clear? Court does call the case of Anderson versus Lyman. State your appearance, please.
Lori Anderson. Armani Lyman.
All right, Miss Lyman, when the court says 9 o'clock, I mean 9 o'clock. We're waiting for you to appear at the courthouse.
Okay.
So that won't happen again, correct?
Yes, sir.
This is the date and time set for trial.
Should I stand there, sir, or right here?
You can stand wherever you want, that you'll be picked up on a microphone. Ma'am, put the microphone back where it was. It will pick you up.
Sorry about that, sir. Your Honor, my name is Lori Anderson, and I am the plaintiff and owner of the property at issue. I am here seeking a judgment for $14,606.46, which includes unpaid rent, court costs, unpaid water bill, and damages in the amount of $2,866. Ms. Armani Lyman provided false information on her rental application, including misrepresenting her residency, which influenced my decision to rent my home to her. This is not a typical landlord-tenant dispute. She has a documented history of property damage, unpaid rent, and destructive behavior, as shown in the exhibits and witness testimony I will present. I want to acknowledge that I appreciate the court's efforts in landlord-tenant cases to maintain tenancy for individuals who might otherwise be homeless. However, this case is different because it involves actual property damage and destruction, not just homelessness. If the court allows Ms. Lyman to remain a tenant, I respectfully request safeguards to protect my home, because this is the only way I will have access to my property. The defendant will not allow me into my home and does not communicate with me outside of the court. While the lease allows me access with a 24-hour notice, Ms. Lyman has denied the entry, making court-ordered inspections necessary. Therefore, I request that the court order monthly inspections at a specific time each month so that these inspections are enforceable and I can return to court if Ms. Lyman fails to comply. Monthly property inspections with Mr. Ivory Clinton present to detect smoking inside the home. Inspection is scheduled once per month on a Saturday at a specific time set by the court, preferably 10 or 11 a.m. During inspections, I request permission to take photos of the property condition. I request access to inspect the entire home, including the basement and garage. I will bring an HVAC filter to the inspection and replace it monthly as part of regular maintenance. Inspections will confirm that there are no unauthorized occupants, no further property damage, and no smoking inside the home. I ask the court to instruct Ms. Lyman to allow access to the home for myself and a licensed contractor on October 2nd to repair a crack in the basement, scheduled to start between 8 and 10 a.m. and expected to last several hours. I am also respectfully requesting that the court return 2 zip drives in my possession. I did not present any video evidence in this trial, and these drives contain precious family memories. For this reason, I ask that these videos not be included as evidence. These measures are essential to prevent repetition of past destructive behavior, ensure compliance with lease terms and local laws, and allow me reasonable access to my property. I respectfully ask the court to grant judgment of $0.46 and Ms. Lyman remains a tenant to consider implementing these court-ordered protective measures to safeguard my home. Thank you, Your Honor.
Ms. Lyman, opening statement.
Okay. So I have not been able to peacefully stay in the house. Every time I turn around, she's either down the street or have somebody watching me. So I would really like to be able to enjoy the home, which I haven't. I pay all this money to not be able to enjoy the home. I don't smoke, so there's no smoking happening on the property. There are no damages. And the judgment, that seems like a much, because she's including the rent that I had paid to you guys in escrow in the judgment. Also, I would like an addendum to the lease for my $750. That she said that she legally lied and said that she didn't know that she can put it as non-refundable because somebody else is suing her for the same $750. When I moved in May, I paid $3,300. It should have been prorated because I moved in on May 5th. So that should have been prorated $533 plus the extra $300 that's left over from the deposit. In June, I paid an extra $200. So I ended up paying $3,500. In July and August, I paid the $3,300. The only month I owe is this month. So from
this month being September or October?
Yes, I can pay that tomorrow. The so only every month is $3,300. So with the extra money, me paying the 200, prorated the $530, the extra $300 from the deposit comes up to $1,033. So I figured that I should take that from the rent, and it should be $2,267.
That you owe.
Yes.
So Anderson, you may call your first witness. Is that gonna be yourself or somebody else?
Okay, should I stand there to question the witness? Where should the witness stand there?
It's up to you. Where do you want to start?
Clinton?
Me?
Your Honor, may I give this to Mr. Clinton to reference?
I don't know what it is.
It's evidence pack number 4 that I've already.
No, that's not the way it's done.
Oh.
Question him and let me try this again. Did you attempt to verify any of the information that is on this application?
Well, the application showed me her pay stubs, so I knew it was through a legitimate company, rent free. They verify information like that, so I saw the 4 pay stubs, so I assumed that's where she works. I thought, I guess I don't need to talk to them since that number didn't work, and so I just didn't pursue that, talking to the current landlord.
So just so that I'm clear, if Miss Lyman would talk to you, let you just come into her premises willy-nilly as you requested, would we even be here?
No, I would.
Okay, that's what my problem is.
I just want to know that the property.
The reason that we're here, is it not, is because she won't talk to you.
I'm concerned about my.
There has been nothing detrimental to that application to you. Is there anything referenced at tenancy that has been detrimental based upon your reliance on that application?
I'm worried about my property, sir. If she does damage to my property, it's going to be well beyond her $5,000 earnest money. I just want to sleep at night and know that my property is safe. That's all I want.
Can you answer my question? I'll try the question again, and even if you want to ramble on. What did you rely upon to your detriment in that application in renting to Ms. Lyman?
I relied on the fact that she wasn't being evicted at her current. It's like,
And you did not do a search regarding Ms. Lyman. What did she put on there that is fraudulent in your mind?
Her current address.
Did you do any other searches, anything regarding Ms. Lyman prior to renting to her? So you took what she said in the application, put it through to a company, and relied upon that. So in point of fact, you didn't necessarily rely upon what Ms. Lyman said. You relied upon what the company gave you back.
But
you didn't rely upon the application. In fact, you relied upon what this other company had reported back. So that's what you relied upon to rent to her, not the application that's been flaunted around here. It was the report back from this company.
I don't want to make you angry, so whatever you want.
Ma'am, I am not angry, and don't try that game with me. If I get angry, you are certainly going to know. Filed a termination case to evict her.
Somehow make sure my house is okay, so
Well, I don't know how you're going to see the latter of that, because at this point, I'll be honest with you, I think you've been harassing her to the point that you've interfered with her quiet enjoyment of the premises. And she may be entitled to damages for that. I haven't made a final decision on that, but I'm just going to tell you, you can't go around, rent to somebody and say they're a crackhead. You might say all of that stuff. It becomes a whole different issue when you begin to disseminate it to other people. And maybe you don't get this, but with regard to the alleged sex offender, I have no idea if he is or not. There's a whole registry regarding that. They're required to give their current address.
I was just concerned, sir. I'm sorry. There's a lot of children running around.
It doesn't matter whether you're concerned. I could be concerned about whoever out there. I don't just go around saying to people, well, they must be a rapist. Oh, somebody's gonna lose. I'm gonna tell you that right now. Ms. Lyman, was there any other questions you had?
No, that's really it.
But Ms. Anderson, you told or intimated to the neighbors that there was crack use at that house.
I just said I saw a crack pipe.
That's all you said?
That's all I said.
Do you have, is that what's said on the text message?
I believe, I'm not sure if she CC'd the court in it, but it had like multiple messages with her and other people and stuff like that as well.
Yeah, I didn't say there was a crackhead.
Saying that it was a rapist in the home, and then people were like,
Yeah,
that it was a
Ma'am, stop. Go
yeah,
ahead.
there was a sex offender in the home, and then she had people like, what is wrong with her? Oh, you need to get her gone, just different stuff like that. She has sent emails with the photos of that, yes.
Well, at this point, I'm not gonna need the copies. Anything else?
Nope, that is pretty much it.
Anderson, anything else from you?
I did look up in public records for iChat for her uncle, and it did say that he was.
Okay, did it give an address? Did it give an address? So how do you tell the people around there that he's living there?
That's what they said. I don't.
I just want to say the person that she keeps claiming that's my uncle, that's not my uncle.
Why do you keep interrupting?
She just searched my name up and just tied that to me.
I want to understand that.
She said she searched my name up and it said
Your name.
Yes, my first and last name. And she said that Google or whatever she searched up in said that he was my uncle.
Is it your uncle?
No.
Is he related to you?
Yes.
What is he?
A cousin. Has he ever been at the property? No.
Miss Anderson, you found somebody who was related to her. Do you have any personal knowledge that that person had been at the property?
Showed pictures of the neighbor from Facebook.
Oh my God.
Because he was saying that the uncle lived there. He said he spoke with the mother, said the uncle lived there. And I said, does this kind of look like him? And he said, yeah, it kind of does. And then I started doing my searches. So this is all based on me doing my searches and trying to figure out who was in my house, who was living in my house.
You can have a seat. You may step down. Here's what I'm going to say. You filed this complaint for unspecified violation.
What'd you say, sir? I didn't hear that.
You filed this complaint for unspecified violations / fraud / misrepresentation of person in lease, which I believe those are two different things because you said you were dealing with somebody else and not Ms. Lyman.
Yes, in the beginning, I was dealing with that lady in the back that introduced herself as Joanne. That's who I was dealing with. She's her mother.
And persons in whole and non-payment of rent. Those are the 5 bases. Violations of the lease are tenuous at best. Fraud and misrepresentation of the person in the lease, which is this other person. Ms. Lyman has been here when the court's required her to be here.
But,
The fraud, stop. The fraud, there would have to be some type of reliance on something, but that's not what you relied upon to rent. So that's tenuous at best. Other than somebody's speculation, which is actually hearsay based upon hearsay, because supposedly they're the persons that are telling you X, Y, and Z. I have nothing to say that there are other people in this home other than your statement. And it looks to me like the rent's paid. What I do, however, see, and I haven't come to a final decision on any of this, I'm just telling you where I'm at, is that there's been an interference with her quiet and useful enjoyment of the premises, and continues to be. And that there are potential damages for defamation, which relate to that quiet and peaceful enjoyment of the premises. So here's what I'm going to do. If you say you want to resolve it, then you need to resolve it. But I don't think, quite frankly, Miss Anderson, you're in a position to get everything that you want.
Okay, sir. Whatever.
So you just have to talk. I'm going to give you two a chance to go out and see if you can resolve it. If not, I'm going to come back in and I'm going to resolve it. And I'm going to tell you that somebody is going to be very, very unhappy. And I'm not saying anybody has to do anything, but I think if one looks at it, you can see where your strengths and weaknesses are. Now, if you want me to make the ruling, I'll make the ruling. I don't have a problem doing it. I can tell you with reference to the claim of the monthly visitation, not going to happen. 750 is a curious question, but may have to be litigated another day. Because as I recall from the previous proceedings, you had agreed that it would be refundable. But now today you seem to be saying that it's not. Court's going to stand in recess. You got 20 minutes. We're back on the record of the case of Anderson versus Lyman. Did you folks come to any agreement or no?
No.
No. Okay, very good. That's fair enough.
Like what I said suggested?
No.
Oh.
Anything you want to say in regard to closing arguments, Miss?
I told Ms. Lyman that I was willing to waive the late fees, to waive the court costs, give her the $300 for refund for security deposit. So I would only be asking for $3,000 for September rent and then $143.93 for May water. I think that's fair. And I also told her I'd be willing to write a statement about the security deposit being refundable if it's in room swept conditions. So I thought that was fair. So all I would be asking for is $3,143.93 for September rent and May water. And then $3,143.93. And that gives her the $300 credit we wanted to give her for the security deposit for September rent. That's waiving all late fees and waiving court costs.
All right.
That's
Lyman.
I feel that I should be compensated because she gave out my social security number and copies of my ID, which was attached to the email. A picture of my ID and my social was at the bottom. I feel that that is defamation to my character, and it has the whole neighborhood in that email. Because I do not know them people at all, and my social is very, very sensitive information.
I did not give her social help.
I feel that.
Ma'am, Miss Lyman, hold on a moment. She did not interrupt you. Go ahead, Miss Lyman.
I feel that the late fees are excessive by some compensation would be nice, just because I haven't been able to enjoy the home. This rent, I feel like I owe $2,267. That's pretty much it. I just want to be able to enjoy the home without being bothered.
Thank you, Ms. Lyman. Well, thank you both very much. What I'm going to do is I'm going to go through these calculations, try to figure this out. There will be no additional argument or witnesses on the case. I will render a decision and I'll set it for October 14th, 2025, 9 a.m. Yes, Ms. Sanders.
Can I get the 2 zip drives that I didn't include as evidence since they have family photos on?
Ma'am, once I am done with the case, I will make a decision on that. I told you that time and time and time again.
That had family photos of my little boy.
Ma'am, what did I just say? Thank you.